I'm joined today by Muvhango Lukhaimane, who's the pension fund adjudicator, and we're going to be discussing a case that was in the press recently, where a fund deducted monies from a pension benefit that relates to a study loan. Now, Section 37D does not allow for that, and I've got Muvhango here to just explain, first of all, what happened with that case, and number two, then what are the circumstances under which deductions can be made under this section of the Pension Funds Act, so that there's 100% clarity out there. Muvhango, good day.
Thank you very much, Chris. Good afternoon.
Hi there.
In this matter of Bokamoso versus the Pension Funds Adjudicator, what happened was that the member complained to us to say that a deduction has been made from their pension fund, and they wanted us to have a look into that. Those of you that are in touch with our office often enough to understand our processes, you will know that sometimes matters are closed as settlements or as out of jurisdiction. Those matters normally would not come to the adjudicator unless there is something that people don't understand. So usually what will come through to me is if at that level there is no resolution and the matter then must be determined, then I will then go through the draft determination that I will receive, see if there are any changes that I need to have made, and then finalize that and issue that, and that will then become a court order. In this matter, what happened was, unfortunately, we had a new employee, and their background was really from the government employees pension fund. And in the government employees pension fund, you can make a deduction for study loans because the government employees pension fund is governed by GEP law, which is different altogether from the Pension Funds Act. So they closed that matter there. But since this employee was just starting out, I was quality controlling what it is that they do so that we can see if they are on the right track. Now, when I then did the quality control the following week, then I noticed that the matter was closed erroneously. We couldn't just leave it like that. So I said the matter has to be reopened because it's wholly incorrect that the deduction could be allowed. We notified the fund to say, we have realized that this matter was incorrectly closed. Here is your opportunity to now, it actually has to be determined. Here is your opportunity now to give us a response. The fund didn't reply to that request to make a response. The days that they were granted lapsed, and then we proceeded and issued a determination. It was then that they raised the issue to say the determination should not have been done. Now, when we were served with the papers, those of you that have the time, you should actually go and the papers are quite voluminous. So when we were issued with the papers to say, we normally, as you know, will not go and defend matters, but the papers had all sorts of other allegations in them, which meant that we had to respond to the papers. Now, this issue had never arisen before. And so from our point of view, if you look at the FSR Act and also look at the Pension Funds Act, it does talk about the adjudicator. So we also needed clarity to say, can any other decision that is made at any other level in the organization be taken then to be the administrative decision that we have done? Because as you know, we are governed by PAJA also, and all the, so we needed clarity also. So we filed our papers. All these things that I have just told you are right at the beginning to say, this is how this matter came to be. This is how the process lapsed. There are confirmatory affidavits to that effect, but also in the papers, if you look at them, there are all sorts of other allegations of bias and this and that I won't go into, because during the hearing of the matter, because we also retained counsel for purposes of the matter being heard, the fund abandoned all those other allegations, and they said, no, we don't now want to proceed on all those other things. We just want this matter to be dealt with on the procedure, to say, was the procedure that was issued correct? We did receive the judgment. As you know, in motion court, that is really the order that you will get. The member was also not there, and then the order was issued. We would also have wanted, because it's the first time that the process to this level comes before court, it would have been in everybody's best interest if the court had actually given reasons to say, this is why we feel that the process that you had followed was not correct. But be that as it may, because we were not actually a party to the matter, we cannot even ask for reasons. But the fund also didn't ask for reasons, but the order was solely granted on what was argued before Honorable Judge Crutchfield, and that was the issue relating to the process. It had nothing to do with the merits of the matter as to whether the deduction for the study loan is lawful or not.
Thanks for that, Muvhango. So what is allowed by the Act? I mean, what are the exact things that it allows for, so that there's no ambiguity here as far as that's concerned?
Yes, the Act 37D talks about the dishonesty that is required. In fact, from the member must have committed some act of misconduct, dishonesty, fraud, and all that against the employer for them to be able to, for the employer to be able to come to the fund and say that I would want to have this deduction made from the benefit. And I think what is key now is they have, since the JEFTA decision in the Western Cape High Court, that provided a lot more clarity, because that was an instance where we had agreed with the complainant to say that the employer was not allowed to make the deduction that they had made in that instance, but the employer took that matter on appeal to the Western Cape High Court. And I mean, we are indebted to the judge that had that matter, because it really unpacked all the other prior legislation and all the other prior decisions, and then really set the tone to say it's even stricter. The employer must have done all sorts of other things. For example, right now, in terms of the JEFTA decision and the latest FST rulings, even if you go and just open a criminal case against the member, the employee as an employer, you will not be able, the fund will not be able to withhold on that basis. The latest decisions actually force the employer, even if they were to withhold and they have a prima facie case, it forces the employer to place its case in front of the fund to take that case, put it to the member and say, these are the allegations that the employer has, what do you say? And only then, when the fund has weighed both sides, can the fund withhold, having considered, or the fund can then choose to not withhold, based on whatever response they would have received. So nothing has changed from this ruling of Bokamoso Retirement Fund versus the Pension Funds Adjudicator. It had nothing to do with the merits of whether a student loan can be deducted, whether, employers sometimes would want to enforce the deduction of, they would say, bonuses that we paid you, we want to recover them pro rata. Some would want to say you left to go to a competitor, therefore we want to claw back certain things. All those things are actually things that come before us, and we then interpret the law and we say, employer, you have not instituted even civil proceedings, you have not placed your case before the fund, you have not gone and sought you have not gone and sought the response of the member before withholding. Therefore, on what basis did you withhold? So, if anything, the cases that have been coming up at court in the past 2 years and also in front of the FST have provided more clarity and really elevated the fact that of what then Section 37A says, to say a pension fund benefit cannot be executed on, cannot be ceded, notwithstanding what is said in the rules. The only exceptions are those under 37D.
100%. And of course, I think there's also mention of a housing loan, but I think that's the only loan scenario that is covered. Nothing else at all. Nothing else.
It's only the housing loan that will also fall under 37D as granted in terms of Section 19(5) of the Act.
I understand. So future steps now. I mean, where does it leave this particular case? What's the future for that case?
Well, for us as an office, it actually means that we have to then go back and refine our process, because if it is indeed the case that a matter that can be closed as a settlement or an out of jurisdiction matter at the level at anyone else's level, then we have to then find a way to say, how do we ensure that lapses like this do not happen? So for us, it's to go back, review our processes, and then say whether it would be that we then escalate everything to be signed out by the adjudicator and the deputy adjudicator. Then that would be the case. But it's now for us in the next week or so to then relook our processes, and you would know, the retirement fund industry players would know that should we then refine anything in our processes, we will inform everyone as soon as possible, give them also time to comment if they need to do so, because really some of these issues that are straightforward, you don't want people to wait long for the process, for the complaint to make it through the formal process, if it can be looked at much earlier and everybody gets to the closure of the matter.
Got that, 100%. Muvhango, thank you very much for your time. I appreciate it. And we look forward to seeing what's going to be happening on this one going forward. Thank you very much.
Thank you very much for the opportunity.